We're talking about the new gun control craze on the West Coast, extreme risk protection orders, on today's AK Show. This is Alex AK Kincaid. Welcome to the AK Show. Like much of our gun control laws, the ultimate goal of extreme protection order laws could superficially sound almost nice on the surface if you give these laws no in-depth analysis whatsoever and thrive on emotional feel-goodiness with the ignorant belief that peace on earth and utopia are sure to follow the positive votes of your politicians. The basic premise of these laws is to allow someone who supposedly knows you and has your best interest in mind to ask the judge to take away your firearms for your own protection or the protection of other people. And not just your firearms. These laws allow the court to remove any deadly weapons, as we saw in the most recent version that was passed in Oregon in 2017. What's a deadly weapon? It's anything specifically designed for and presently capable of causing death or serious physical injury. So what might that include? Your knives? Your bow and arrows? Maybe a rope? Basically, it's anything that you might own to defend your life, which will now be removed from you, and you won't even know about or have an opportunity to tell your side of the story until after the court issues the order. I know you'll be shocked, but out west, this new craze that defies not only the Second Amendment, but our supposed constitutionally protected right to due process started in California in 2014. And it was followed by the Washington voters in 2016, wherein Washington passed a similar version. And now Oregon has fallen to this same craze. And these laws have kind of been around since at least 1999, but these laws that have been in place are different. These versions that preceded our most recent family members being able to come into court and take away your gun right laws actually required law enforcement to request that guns be removed. And I'm not saying those are great, but what California did, and then Washington and now Oregon, is a huge step above and beyond what we've seen in the past. California took the laws to a new height by allowing family or household members to request that guns be confiscated. So how do these laws get passed? Well, for starters, some people just don't understand and therefore hate firearms. And there is almost always the usual emotional plea with the story of harm caused by guns. Maybe someone committed suicide, someone was hurt, someone was murdered. And politicians tout these new gun control laws called extreme risk protection order laws and push them on the public by persuading people that the laws are for the best. Family members who supposedly know when a person is in danger to himself or others, even though the person may never have been committed or jailed before, can come into court and ask that guns be confiscated. This entire idea, of course, is seriously flawed and very dangerous for any American citizen. This is, of course, why our Constitution is designed to allow anyone to present their side of the story before being stripped of their basic God-given, human, supposedly constitutionally protected rights. Let's look at a couple of examples. I prosecuted for years, and now I defend, and I have seen firsthand over and over and over again how people lie, even in court, how people abuse our justice system for personal revenge or control, and how easy it is to get a restraining order against another person, even when there's no basis for the restraining order. So let's look at how that happens. Way too many restraining orders are issued by courts because someone wants revenge or the upper hand in a lawsuit, such as a custody battle. All a person has to do is go to court and lie. There is very rarely additional evidence above and beyond that witness testimony when the judge first issues a restraining order. So for example, think about an abused woman who finally decides to leave her abuser, because part of these extreme risk protection orders is, of course, supposedly to protect people and to protect women in abusive relationships. But I'm going to show you how the tables can turn and this actually works against such a woman. Maybe this woman who's leaving buys a gun for self-protection and her abuser uses this new law to file a petition, go to court, and tell the judge that the woman who's just left him, maybe taken children with her, is suicidal. She's gone off the deep end. She just bought a gun. He's extremely worried about her well-being. Now what happens? Abusers are manipulative, they're narcissistic, and they will often do anything and everything they can to regain control of their victims. This new law will allow the judge to believe the supposedly loving husband who has secretly been beating his wife and maybe their children, and strip her of her constitutionally protected right to defend herself, which may be the only way she can defend herself against this person, on the false belief that she supposedly may harm herself or their children. And this woman in this story won't even know this has been done, that the man has gone to court and lied and told this story, and that her rights have been taken away, until the police come to take her newly purchased means of self-protection, her new handgun, away from her. Let me give you another example. I work with senior citizens every day. What about an elderly, let's think about an elderly, grandmotherly woman. She has a loser grandson. And the loser grandson and his girlfriend move in with her rent-free. This elderly woman has a handgun by her bed because she's afraid of her grandson. She finally gets up the courage to tell him and his girlfriend they have to leave, and instead, they see their free rent going away. They go before the judge and tell a sob story of how grandma has dementia and needs protection, how she's been waving a gun around when she thinks she hears a noise, and voila, her gun is gone and she is defenseless against her abusive grandson, his girlfriend, and his druggy friends who come and go all day and all night. Any lawyer who routinely deals with restraining orders knows that in restraining order hearings, there is rarely any evidence besides what the person requesting the order tells the judge. In other words, your family member now, under these state laws, can go to court, tell the judge a story, and that's all there's going to be. And judges accept, very often, most often, they accept that testimony without anything else, without anything to back it up, because they don't want to deny a restraining order and be wrong, and then someone gets hurt or killed because they denied a restraining order. So they hand these pieces of paper out, restraining order, like candy on Halloween. Again, these orders are issued by judges without any notice to you and no due process of law before stripping you of your Second Amendment protection. And only one person needs to convince a judge that the order should be issued and your gun rights are gone, just like that. The order will require law enforcement to confiscate your guns if you don't turn them in within 24 hours. And unless you file for a hearing, that order is going to stay in place for a year, and it can be renewed every year. On top of it, these laws also allow any police officer to go to court and request a judge to take away your gun rights. I defend police officers. And here's another thought. What about their liability? What does this do to them? What burden is this on our law enforcement agents who are trying to do the right thing, who don't want to unnecessarily strip people of their Second Amendment protection? Now the public's going to blame them if they don't ask judges to take away guns, like they're supposed to somehow foresee the future. How are they going to handle this new pressure? So, the latest version that was passed in Oregon was pushed by a senator who exploited the suicide of his own stepson. And ironically, there's not one word in the bill about offering any help of any kind to people who are truly self-destructive. I prosecuted for almost a decade in Oregon, and I also continue to practice there in private practice. Oregon has, for years, suffered from a severe lack of mental health assistance for those in need of help. And during my years as a prosecutor, I remember that many people who needed help only got it from the state or the county after they committed a crime and wound up in the criminal justice system. We'd file charges against that person. I remember a mother calling me on the phone and begging me for help for her son, who she knew was mentally ill and who was arrested over and over again for petty crimes. He finally stabbed a cop and was sent to the state mental institution, and that's how he finally got the help he needed. The criminal justice system is a revolving door for the mentally ill to come in and out of the courtroom on different charges until they commit a crime severe enough that they are sent to the state mental institution. And that is the reality of what's happening in states like Oregon. So what does this have to do with the extreme protection order laws? Well, every state in the country already has laws that allow a person to be involuntarily committed for 72 hours for a psych eval. These laws are already in place. They work much the same way as these supposed extreme risk protection orders do. A family member, a household member, law enforcement, a counselor can come into court. The counselor will do an evaluation of the person. The judge is allowed to commit the person for their own protection or the protection of other people. Why are we focusing on guns when we already have a process, perhaps a better one, that will allow you to be kept in a safe place and receive the treatment you need instead of being stripped of guns and left for dead? I mean, think about it, right? If someone is contemplating murder or suicide, are they really going to be deterred by having their guns taken away? Or are they going to become even more intent on carrying out their task? Extreme risk protection order laws are gun control laws. They're nothing more. The cops can show up, take the guns away from a suicidal person, and they will, unfortunately, use a rope if that's what they want to do. The systems we already have in place to have someone committed for 72 hours is a much better system because the person can actually get help. We're not just stripping them of their guns. So these new laws, nothing more than focusing on the guns. It's another way for guns to be taken away from people unnecessarily. And it's a feel-good law that the public says, why wouldn't we want to do this? Instead of focusing on the real problem, the root cause analysis, if you will, the focus is on finding another way to take guns away from American citizens. And that's why I don't like and I don't support extreme risk protection order laws. And if the court issues an extreme risk protection order against you, you may be defenseless for at least 3 weeks because the law doesn't require that you even have your day in court to defend yourself until 3 weeks after the judge issues the order. 3 weeks after you've been stripped of your rights. Be aware, if these kinds of laws are proposed in your state, please understand what they're doing. And as always, the truth is in the details. I'm Alex A.K. Kincaid. Stay vigilant. Get Alex A.K. Kincaid's book, Infringed, The Gun Owner's Guide to Gun Rights. This is Alex A.K. Kincaid, and thank you for watching The AK Show.